Hello and welcome to the next alumni webinar, The Life Cycle of Estate Planning with Joan Garrity Flynn, Esquire, parent from the class of 2011, 2009, 2005, and 2004. I'm Maura Sweeney, Director of Alumni Career Development at Holy Cross, and I'm happy to welcome you to today's webinar offered exclusively for Holy Cross graduates. We'll be together for an hour. After the formal presentation, Joan will take questions from you for as long as time allows, and we hope that you can stick around. I encourage you to submit questions throughout this presentation by checking out the question function located on your webinar control panel. While you're there, you can also download a copy of today's slides by locating the handouts function. This presentation is recorded and will be emailed to all participants in a few days. A copy of the slides will be included in the email. Now it's my pleasure to introduce you to Joan. For over 30 years, Joan Garrity Flynn has worked with individuals and families on their personal planning needs, including estate, gift, and charitable planning, as well as probate and trust administration, and probate court equity matters. Joan serves in various fiduciary capacities, including as executor and as trustee for private family trusts and charitable foundations. Over the years, she has been active in her Weston, Massachusetts community, her parish, and with charitable organizations. She oversees the estate administration practice at Hemenway and Barnes, LLP, is chair of the firm's Associates Committee, and recently stepped down as co-chair of the firm's nonprofit practice group. We at Holy Cross are grateful of her work as chair of the 1843 Legacy Society. With that, I'll turn things over to Joan.
Thank you, Maura. I'd like to let everybody know how pleased I am to be here, and I welcome all of you to this quick primer on estate planning. I'd like to let you know that while I'm not an alumna of Holy Cross, I do hail from quite a long purple line. My grandfather was in the class of 1905. My father and his brothers followed in the 40s. I'm the oldest of 9, and 5 of my siblings are Holy Cross grads, as is my husband, Greg, who was in the class of 73. So I really feel quite blessed and quite familiar with the school and the efforts that are being made with alumni and with development, and it just makes me very happy to be able to share with you what I do on a daily basis. So I hope everybody can see the slide presentation in front of them. And with that, we're going to get started. What is estate planning? Simply put, estate planning is about making a plan in advance and naming who you want to receive the property you own after you die. It is about ensuring that your intentions will be carried out. An important point to mention is that estate planning is not just for the wealthy. No matter how large or how small the size of your estate is, everybody has an estate and has wishes and desires as to how their property should pass. These wishes and desires change as you move through different life stages and your priorities and needs change. Over the years, there are different triggers that will warrant a review and update of your estate plan, such as changes to your personal and your financial situation, marriage, divorce, other relationship changes, the addition of children, the loss of family members, changes to the estate tax laws, or changes to your domicile, you move to another state, or inheritance or other large infusions of wealth. As my goal today is that you will take away from today's presentation a greater appreciation that estate planning should be ongoing, much like the focus given to your personal and financial health. What happens if you die without a will? That's commonly referred to as somebody dying intestate and not having done estate planning. All of us live in states that have probate codes that do govern the disposition of your probate assets. In a minute, I'm going to explain what probate assets are. The important point is to know that your home state, and here for me it's Massachusetts, has a code, a probate code that dictates where property passes in the event of an individual's death who dies without a will. And that probate code, combined with the size of your estate and the recipients of your estate, will determine whether your estate owes estate taxes and how the payment of any estate taxes owing is allocated among the beneficiaries. That might provide assessments on individuals you did not want to burden. So it's quite important to focus on that. Turning the page, you'll see that I have broken out the two categories of assets. They're probate assets and they're non-probate assets. Probate assets are those assets that are titled in your individual name. The simplest explanation is a bank account titled in the name of Joan Flynn. Probate assets become frozen at the time of my death. That account will be frozen. And it will be necessary for a personal representative, an executor of my estate, to be appointed to have authority to transfer that account after my death. That account, if I leave a will, that account will be governed by my will. If I die without a will, the disposition of that account will be governed by the Massachusetts intestacy statute. So when you think about it, many of us own assets that are just titled in our individual name. I mentioned the bank account, investment accounts, real estate. You might own a piece of real estate in your individual name. Simple things like your automobile. And then there are categories of assets that many people don't appreciate or recognize are probate assets, such as payments that are made upon their death. For instance, the most common payment would be refunds payable at your death. You might have an income tax refund that hadn't been issued at the time of your death, or you might have final salary payments due. So these assets all fall within the category of probate assets. And the important message to take away is these assets need a will to direct their disposition. If in the absence of a will, your state's intestacy statute will direct where those assets pass. The other bucket of assets is referred to as non-probate assets. And those are assets that pass what is commonly referred to as outside the will. You do not need a will to direct the disposition of those assets. Non-probate assets include assets where you may have designated a beneficiary or which pass by operation of law or by contract to named beneficiaries. And the beneficiaries in this example would not be your estate. So examples of non-probate assets include life insurance policies. Everybody executes a beneficiary designation form for their life insurance. Similarly, retirement benefits that have beneficiary designation forms. Those benefits pass to the named beneficiary. Owning property in joint name with right of survivorship, either with your spouse and or other beneficiaries. Those assets pass by operation of law to the surviving joint owners. Increasingly, we're seeing what are referred to as transfer on death or payable on death bank and financial accounts. These are accounts that when they are opened in a bank or financial institution and the signature cards are filled out, the owner would say, I'd like to have this account payable on death directly to my son or grandson or whomever. The other category of non-probate assets are assets that are in an individual's funded revocable trust at the time of their death. And so they would pass according to the terms of the trust. So again, two buckets of assets: probate assets, which are subject to the probate code in your estate, and the non-probate assets that pass outside the will or the intestacy statute. Part of estate planning is making sure that the disposition of both the probate assets and the non-probate assets are coordinated. Very quickly, the next slide illustrates the Massachusetts intestacy statute, which is here would control my estate if I died intestate without a will. And every state in the United States does have an intestacy statute. For the most part, they're pretty similar. As you'll see from looking at the slide, in most cases, if you have a spouse and children, the spouse and or the children are the first line of beneficiaries. Where it starts to change is when situations when, for instance, you might be in a second marriage and have married a spouse that has children from the first marriage, so the children are not all from the marriage. That in Massachusetts, our intestacy statute would allocate the assets in that event between the spouse and the decedent's children. A surprise that many people don't appreciate is if there's not a spouse and there are no children, most states would then provide that the beneficiary of the person's intestate estate is the person's parents. You could have a situation where a 50-year-old dies intestate, not survived by a spouse or children, and find that his 85-year-old parents are the beneficiaries. And they might have no interest. They might not want to receive the asset. They might have created their own financial plan where an inheritance would counter what they've tried to do. And then there are the situations where there are no parents and everything would pass to siblings. You might be estranged from a sibling. In an event like that, your wishes would not be included if you were to die intestate. And the other final important piece is if you're somebody that likes to provide for charity or some gifts at death to charitable organizations, they are not incorporated at all under the intestacy statutes. Another factor that is very important when you're talking about estate planning are estate taxes and how they will affect your own estate. In the United States, we have the federal estate tax, and then right now of our states, probably 15 have estate taxes, and I think 6 have inheritance taxes. Not surprisingly, most of a concentration of states that have estate taxes are right here in the Northeast: New England, New York, Pennsylvania. The federal estate tax, in recent years, there is an exemption from the estate tax, which has increased. It's currently at a level of $11.4 million per person, which means a married couple together could shelter almost $23 million from the federal estate tax. That means that most Americans are not going to be subject to the federal estate tax. And that's really a wonderful thing. When I first started practicing, our exemption was down to, I think, $1 million, and our federal estate tax rate is 40%. So that is viewed by many to be a confiscatory tax, and the fact that we currently have this high exemption eliminates this as a tax planning concern for most people. I do note that under existing federal tax laws, the $11.4 million exemption is scheduled to sunset and revert back to the prior exemption of just under $5.5 million in 2026. We're just going to have to wait and see what happens, watch the elections, see which house is in control. In addition to the federal estate tax, as I mentioned, in Massachusetts, we are subject to a Massachusetts estate tax. our estate tax in Massachusetts is still geared into what the old rates were under the old estate tax system. So we have an exemption equivalent amount here in Massachusetts, which is only $1 million. And that would also include taxable gifts, meaning gifts over the annual exclusion amount if you make those. We have our rate of tax in Massachusetts averages 10%, ranges from 5 to 16%, but so it averages 10%. The other takeaway piece on estate taxes is that any amounts that an individual leaves to his or her surviving spouse or to charity are not subject to the estate tax. While the assets are included in the estate, there's an offsetting marital or charitable deduction for the assets passing to the spouse or to charity. So that is clearly a powerful planning tool available that can reduce the tax burden. So you'll see we have, we're trying to illustrate here, estate planning is something you just want to revisit throughout your life. And one of the, I think one of the easiest ways to appreciate the significance of needing to focus on estate planning is to look at yourself at different decades in your life. So we thought it would be helpful to start with when do most people first create estate plans? Typically, it's when they're in their 30s and 40s. Oftentimes, it's when a young couple gets married, or there's a baby born, or a child adopted. That's when couples realize, look, we need a will. What happens if something happens to one of us? Who's going to have authority and responsibility for the kids? Oftentimes, estate planning for young couples is really not geared towards tax planning. It's really for the orderly disposition of their assets and how everything will be handled if something happens to both of them. And young couples typically start out with, they have their first house, they have a mortgage, they might have savings, but those are still growing. They might be lucky to work in companies with good benefits where they have either some nice group term life insurance, or they've made some purchases of individual policies, and they're starting to build their retirement. They're taking advantage of what their firms offer them. So in Massachusetts, as I mentioned, the tax planning is not the big focus of a young couple's estate planning. It's having wills so that any probate assets, and when you look to a young couple, in most situations, a lot of the young couple's assets tend to be titled in joint name. So young couples typically like to leave all of their assets to the other or to a trust for the other. And their focus is really more on planning for what happens to the kids if something happens to the two of us. So you can have simpler documents. You'll see, we call them I love you wills, where essentially the estate planning is quite simple. The will leaves all assets, probate assets, to the surviving spouse. The non-probate assets are all either in joint name with the surviving spouse as the joint owner, or their beneficiary designations naming the surviving spouse. The wills would focus on who should be appointed as the personal representative, also known as the executor, and in the case of young children, focus on the naming of guardians and conservators for any child who's under the age of majority, which is 18 years of age. Frequently, there'd be a corresponding trust set up for each spouse, or a joint trust for both of them that would capture all the assets at the surviving spouse's death and have a vehicle in place for financial management of the assets for the children until they reach designated ages. As important as the will and a trust are in estate planning, there are 2 to 3 lifetime documents that are every bit as important. One is known as the durable power of attorney. This is a power of attorney where an individual names another person to have authority to manage his financial affairs while he is living. It could be as simple as somebody's in the military and overseas for a year, or somebody has gotten very ill and is in a coma. So having a durable power of attorney in place created when you do your will and possibly the trust is just as important, because if you have a durable power of attorney in place when you become incapacitated, there's an ability to just continue to manage the assets through the durable power of attorney and avoid supervision of the probate court. The other document is known as the healthcare proxy, which is essentially a power of attorney for healthcare. In Massachusetts, that becomes effective when a person is unable to communicate their healthcare decisions. All states have these statutes. Some of them also have directives, medical directives. In Massachusetts, we incorporate that into our durable power of attorney. Homestead, I have included on the outline. Homestead is when it's a creditor protection option available that you can elect homestead on your house so that after your mortgage, there'd be protection. The amount is based on various states that would be available before other creditors could reach the property. And then in your 30s and 40s, life insurance, as I mentioned before, the insurance, you might still have group term insurance, or young couples might focus on the fact that as one spouse is doing better and creating a higher level of income, they want to consider life insurance as a wealth replacement, at least to tide the family over until a certain point. So life insurance gets a little more focus. Then we move to our 40s and 50s, and typically families are growing. You might have teenagers, might have kids hitting college. Hopefully the assets are growing, even though you're trying to pay for places like Holy Cross. Retirement assets are growing, savings. So it's always the appropriate time to reassess your original plan. Some of the reasons to reassess have nothing to do with asset planning or tax planning. It's just making sure that the people you've named as fiduciaries, the personal representatives, trustees, guardians, that they're still appropriate. Oftentimes I see young couples naming parents as executors and guardians, and possibly even trustees for a young family. Well, maybe by the time you're in your 50s, your parents could be in their 80s, and they're no longer the appropriate people for this role. Unfortunately, people deal with changes in their family situation. Divorce, second marriages, you might have children, or even possibly at this point, grandchildren with special issues, or you might be part of the sandwich generation with an aging parent that you're trying to help contribute to their costs. So again, having a review, taking a look at your financial and your estate planning, looking to see how assets are titled between spouses. One point to mention is that we don't know typically, usually, which spouse is going to die first. So you always want to be sure if you live in a state where there's a limited exemption, like Massachusetts, we want to be sure that the first spouse who dies is going to have enough assets in her or his name to be able to take advantage of the Massachusetts estate tax exemption. So it's important to see how property is owned. Again, is your life insurance adequate? How are you taking, what steps are you taking to ensure you have enough money to educate your children? Or are you at the point that you're thinking about possibly looking at long-term care insurance and really focusing on your retirement savings, doing all you can to put as much as you can on a tax-deferred basis into a retirement plan? If you're fortunate enough to be doing well, it's a great time to start thinking about gifts. Under the tax laws, you can make annual gifts of $15,000 per year to anybody, as many people as you want. Spouses together, that bumps up to 30. Luckily, we, having the experience of Holy Cross, it's been ingrained to think about others. Many people are more aware and think of others. They do their own charitable planning, and you start to see more of that at this point in a person's life. It also might be a time where somebody's fortunate enough to be able to have additional homes. Looking at how those homes are titled, that's also part of the estate planning, without even realizing that you are doing estate planning when you purchase and take title to a second home. Moving along to our 50s, I'd like to think that's just a nice little window that hopefully most of us can enjoy between the busy years of raising children and then health issues as we get older. But it's a time when children tend to be educated, they're grown, they're finding their way. You might be lucky enough to have grandchildren, more disposable income. Hopefully portfolios are growing now. Again, your retirement bucket is growing. So many people are at the point where they can consider more sophisticated estate planning and retirement planning strategies. Typically, we see more people in a position to do more significant gift programs, both personal, shifting wealth down to lower generations in the family, as well as to charitable, more use of trusts, planning in a way that you can give it away, but also save it for a rainy day if you need to. When you make gifts at this point in your life, there are real benefits to make the gifts, but there are some possible downsides. When you transfer property as a gift during life, the recipients get your own cost basis, your tax cost basis, whereas if you die owning the property, the beneficiaries get what's called a stepped-up cost basis. So if, for instance, if you're talking about transferring a vacation home into a trust to benefit the next generation, you want to think about they'll be getting the cost basis that you have. What if you waited and that transfer took place at death and there were other transfers? That's the kind of thought process you go through. By this point in a couple or an individual's life, there's a little more comfort in discussing financial or estate planning with the next generation, a sharing of what the plan is. And there's also a greater awareness as to who your children or grandchildren end up with, whether they are candidates for premarital agreements, whether you're selling a business, or what kind of succession planning do you have in place for the business. I mentioned family real estate, especially vacation real estate. It's wonderful to be able to plan for real estate. It's also very challenging, and it gets a little more difficult with each succeeding generation as the numbers grow. Clients amass over the years different kinds of assets, art, antiques, and collections. They create their own issues. One is a valuation issue. what are they worth? How do you allocate them among the children? Are they candidates for charitable gifts? Is there, how do you want to do that? That planning takes additional time. And then the bigger one that we're seeing more and more, people are living longer. When you're in your 70s, you know, our average life expectancy, I think, is 85 now. And so people need to be planning more to be able to support themselves over the longer term. So planning for your long-term care needs becomes increasingly important. You know, how long are you going to keep the house? Are you going to go to an assisted living community? Assisted living communities are wonderful. They are also very expensive. How do you plan to finance that? And then, again, you're really approaching retirement age, not in the sense, retirement age under the ERISA, the federal retirement laws, which is when you're 70 and a half, you have to start withdrawing out of your retirement plans. So discussing retirement planning, what your income is going to be, that begins to take on more of a focus. When you hit 70 and a half, that's why this slide really focuses on retirement elections. You have to make your elections. It all depends what kind of retirement benefits are available to you. You might have your own IRA. You might be fortunate enough to have a large a pension from that, or an annuity that you can count on for your lifetime. You'll want to think about how you make your beneficiary designations. Are you electing, if you're married, a joint and survivor benefit? There are times that couples analyze their retirement benefits, and in some situations, it doesn't make sense to elect joint and survivor. It's all very individualized. One feature that became available in recent years is that the law has finally made permanent an ability, once you've reached 70, to have charitable gifts made directly from your IRA account. This is a really great feature that that can both benefit you, the individual, as well as the charitable recipient. As many of you know, once you reach your mandatory retirement distribution age at 70 and a half, by law, you must take required distributions on an annual basis throughout your lifetime. And these distributions carry out income. And if you want to take advantage of this ability under the tax laws to have direct charitable gifts made to charitable institutions from your IRA, that can be done with the custodian, with instructions from you, and the gifts to the charities will be treated as satisfying your annual distributions. They will not be income to you. Correspondingly, you will not be able to claim the charitable deduction. But for many people whose income is adequate for their retirement needs, this is a great way to both benefit charities and also not be hit with additional income. Again, as in all the prior decades, you still want to take a look at your estate plans, non-tax reasons. Take a look at your fiduciaries. At this point, many people are more comfortable, or they're naming their grown children now. Take a look at your lifetime planning documents that I mentioned earlier, your durable power of attorney, your healthcare proxy. These become real. These are important because there's a very good chance they're going to need to be activated, in somewhere between the 70s and the 90s. Many people retire to change their domicile. They retire to Florida or New Hampshire. Some go for tax reasons. They go to non-tax states. Others go for the weather, the Southwest. And when you do change your domicile, you really want to follow the steps that are necessary to make sure that the state you're leaving recognizes the change of domicile. And that involves executing new estate planning documents in your new domiciliary state, reciting that you are a resident of the new state, and taking the other steps to just to further document your residency, residing there for more than half the year, filing income tax returns, all those indicators that you have truly changed your residence. And if you do change your domicile, it's important to be careful about real estate you still might own in the state you left. I'll use Massachusetts as an example. We have many clients that retire, move to Florida. They still have a house on the Cape or in the Berkshires. Massachusetts will still tax this property because it's located in Massachusetts in the case of a non-resident. So more planning to keep in mind with respect to that to make sure you're structuring it the right way. Reassessing your fiduciaries. If you're in a position to make gifts to reduce your estate, even if it's just for state death tax purposes, that's important that you keep doing that. GST planning, that's generation skipping planning. That relates to planning for your grandchildren or more remote descendants. Under the federal tax rules, there's another layer of tax. Most individuals are not subject to this tax because it's at the same $11.4 million level that the estate tax is. But there are ways for the wealthier people who want to do planning for grandchildren and make gifts to them. There are vehicles available. More and more charitable planning. Again, it can be outright gifts. It can be gifts under estate plans that take effect at death, and can be lifetime gifts that are part split gifts with the charity. Maybe that you receive the income during your lifetime and the charity gets the principal at your death. Another interesting conundrum that some people face is inheritances. To be, 85 years old and learn that your brother died and named you as the beneficiary of his estate, that's a wonderful thing, but you might feel, look, I'm in good shape. I don't need this money. It might be possible for you to disclaim, that is, refuse to accept the gift, and then the gift would pass in accordance with your brother's will, which might say it passes as if you were deceased, and it would pass to your children. That might be a wonderful way to make a non-taxable gift to your children just by disclaiming. But disclaiming requires legal documents. In many cases, documents need to be filed in the probate court of the decedent. So something you would, again, be wanting to think about and get advice regarding. Oftentimes for our elderly clients, we have life insurance policies. They begin to age out. They outlive the coverage span that they have. So you want to be aware of that before that cliff arrives. Again, long-term planning. I mean, the longer you're able to remain independent, that's a wonderful thing, but you can't really lose sight of the fact that that might change. One thing that becomes more important is, while it's always important, it's more heightened, is keeping your financial information organized. It's really important that if something happened, somebody goes into your house, you have kids arriving, if you haven't shared information with them, just to know that you have a file, with important numbers, who to call. That really will make life easier. Sometimes your attorney would have a lot of that information, or at least enough information to work with the beneficiaries of your estate to get them started. So I can't believe how quickly our 40 minutes have gone, but what I hope I've imparted to you is basically the importance of having an estate plan and the need to revisit it over time, and also increasing your awareness that estate planning isn't just about signing a will and a trust and other documents. It's also how you title your property. It's how you fill out that beneficiary designation form for your life insurance or for your IRA or that joint account you take out. And understanding that all of these acts and the effects of these acts are going to change over the extent of your lifetime. So again, I hope I leave you with some takeaways, and I'm happy to turn the program back to Maura and discuss any questions.
Thank you very much, Joan. And I really appreciate the amount of care that you've put in. That was a lot of really valuable information. And we've already gotten some really wonderful questions from the people listening today. Before I jump into the Q&A, I would like to introduce everyone to two of my colleagues who are joining us in the studio today. I've got Catherine McKay. Hi, Catherine.
Hello.
Catherine is Holy Cross's Director of Gift Planning, and Bruce Pelosi. Hi, Bruce.
Hey.
Bruce is the Associate Director of Gift Planning, and together they oversee the 1843 Legacy Society, which consists of alumni, parents, and friends of the college who have told us that the college will be receiving a gift from them as they pass away. And so they have a lot of expertise to share and to contribute to this conversation. And before we jump in, and as you're typing in your questions, Catherine, I'd love it if you could give us a quick explanation of how you help alums in different life stages think about whether they can give a gift to the college after they pass away.
Great, thank you. So the wonderful thing about the work that Bruce and I do is that it doesn't matter how much is in your bank account or what your assets are. Virtually everyone can make an estate gift to Holy Cross. That is a gift that comes to Holy Cross after they pass away, because you can do it in any size. So for example, if you happen to have a retirement account through your employer or a life insurance policy through your employer, you can name Holy Cross for 1% of that and 99% to your family. So everyone can participate, and it's a deeply meaningful process for people. What we like most about our work is sitting down either in person or over the phone or via FaceTime or Skype, and having these meaningful conversations where you think about what's important to you, what do you want your legacy to look like. Most people want to make sure they're taking care of their family financially, but they also may want to make gifts to the organizations that have really helped them, have shaped their life or their success. And so that's really what we do, is we talk to people about how they would like their gift after they pass away to have a positive effect that continues on in perpetuity.
That's wonderful. And I know at Holy Cross, we're always grateful for the generosity of our alumni, and if anything, just the amount that people care for this place. So I appreciate the work that you do. So when we jump into the Q&A, one of the first questions that I think is really wonderful is, where do we start? And Joan, do you have any advice for how we select the right person to guide us through the planning process?
Sure. I think I would compare it to a lot of other projects a young couple or a newbie at this might want to undertake.
Yeah.
You talk to friends. If you have family members who are attorneys, you mention it to them. I think my advice would be talk to friends, see if you get overlapping referrals, so that's a good sign. And then if you're given an attorney's name, one of my suggestions would be that you make sure that the attorney does have a focus on estate planning. You know, it's great to get an attorney's name, but if the attorney is an employment attorney, that's not going to be the most efficient way.
Right. Well, and it's wonderful these days. I think we have so many resources at our disposal. It can almost be overwhelming to know where to start. And so thinking of going right to your friends and families definitely makes the most sense.
Right.
Another question that's come up that's interesting to think about these days is, what is the best way to share your estate plan digitally and updates to that estate plan? Would you recommend that, or would you recommend having it in hard copy?
Well, I can tell you what our practice is. First of all, you execute original documents. You need to have original documents, at least in Massachusetts.
Sure.
So our clients sign hard copies of one copy of their will, copies of a trust, durable power of attorney, healthcare proxy, HIPAA release form. We then, though, we do make electronic copies that we provide to our clients, and we give them the choice. Some want a binder. Quite frankly, it's a generational thing, as you might expect. Yeah. Younger people are happy with digital copies. More senior clients, they like the books with all of their documents neatly arranged and tabbed.
Okay, good. Here's a question that falls in line with that about the contents of a safe deposit box. Can those be considered non-probate if the signature card has two signers?
No, basically, there are two questions there. One is who has access to the box.
Yep.
The actual contents within the box, that really determines who's the owner of that property. That's determined by who's the owner of that property. So a typical example would be a married couple. They have a safe deposit box. They might have, typically in a safe deposit box, although it's funny, I think safe deposit boxes are on the decline a bit in today's world. They might have jewelry. Some people used to keep their sterling silver in it. Important documents like real estate deeds, wills, things like that. So two issues, as I said. One is in whose name is the box and who has access to the box. Typically, a married couple or even a parent and a child would have more than one name on the box, because what you don't want is to have the owner of the box die with the original will in the box and nobody has authority to get access to the box or even read the will to see who's the named executor.
Yes.
So what many firms do, what we do is we retain our clients' original wills in our client safekeeping vault here at the firm. And the clients have copies. The copies indicate where the original is held and a contact information for the attorney. Then the actual contents of the box, well, if it's mom who died and mom's jewelry is in the box, that asset jewelry is governed by the will.
Okay.
Or owner if it's...
Well, and that actually leads to a perfect segue of another question about probate assets, which include like coins and jewelry. Are those eligible for a stepped up cost basis? You mentioned that with real estate.
Good question, Maura. Yes, all assets in a person's estate benefit from the stepped up cost basis.
Okay.
All of them. Jewelry, tangible personal property, stocks, bonds, real estate, they all benefit.
Okay, great.
Yeah, so I had briefly alluded to that point when you're thinking of making gifts, and use the example of a family vacation home. Should we just give it to the kids, or should I let it pass at my death according to my will or my estate planning documents? If my estate is not above 11.5 million, and I happen to live in a no estate tax state like Florida, then it makes sense, if you have appreciated real estate, to pass it at death with a stepped up basis rather than to make a gift of it earlier. And if the children wanted to sell it, they would have to recognize the capital gains based on your original cost basis plus capital improvements. So you have to really analyze each particular asset and what the plan is for that asset.
Mm.
Yeah, and that's a really good thing to consider. I had a friend whose parents passed, and the children found gold coins hidden in a statue in their house, and it wasn't covered by the will, so there was a lot of family infighting over it. So if you have hidden assets, it's probably best not to keep them hidden from your will and your estate.
Yeah.
Well, ultimately, these assets are going to be found. And that does sometimes happen. You find assets that were not reported in a prior estate. You run into that, especially sometimes it's real estate. And sometimes you have to go back and probate the will of somebody who's been dead 20 years just to clear the title for the real estate to be able to pass it. So it's not always, you think, some people think, oh, we didn't have to do anything, not meaning we can get away with something. But what many people fail to appreciate is that it often results in greater work after death than had the planning been done before.
Yeah. Oh, good. That's a good thing to think about. And this actually, the real estate question that you mentioned was another wonderful segue, because someone asked, is the governing disposition the state of residence or the state of death?
Well, no, it's the state of domicile. That's the term, the state of domicile. Gotcha. So for instance, if you are a Massachusetts resident and you die in Massachusetts, you happen to die on vacation in Florida, you're still a Massachusetts decedent. The fact that you died in Florida doesn't make your estate governed by the laws of Florida.
Okay.
Similarly, and we see this happen a lot. I'm dealing with an estate right now where a person was diagnosed with cancer, a Florida resident who was up in Massachusetts and ended up getting care in Boston and kept coming back to Boston for care. But she remained a Florida resident,
right? Even
though she spent a lot of time in Massachusetts. But we were able to demonstrate that, she wasn't residing here, and she was strictly here for medical care. But you do have to be careful.
Right. Okay, that's good to consider. Another question came up, and this was specifically for those who live in Massachusetts, and they said for a couple who lives in Massachusetts, can trusts shelter 1 or 2 million from the mass inheritance tax?
Yes, and I briefly alluded to that. When you have, the example I believe I gave was when you have a young couple and the assets don't exceed $1 million, and that's after netting out mortgages and debts. So, you could have a $2 million estate, but if you have an $800,000 mortgage and some other expenses that are deductions, you might end up with only, $1 million estate. Well, if that's the case, it doesn't matter. You're never going to need more than the $1 million exemption. But the minute your assets get closer to get in excess of $1 million in Massachusetts, you do need a little more sophisticated planning. You do need to have a trust so that the first spouse that dies, and I mentioned how important it was that between spouses, how assets are titled, because the goal is when the first spouse dies, and oftentimes we don't know which spouse that will be, you want to plan for at least $1 million to come into that first to die's trust so that it can get the benefit of the $1 million exemption. Because if you just leave it all to the surviving spouse, and at the surviving spouse's death, it's a $2 million estate, that surviving spouse only has his or her $1 million exemption. So to capture the $2 million, you need to, and this is in Massachusetts, based on our exemption, you need at the first spouse death to have that spouse have at least the $1 million in her or his name. So it would be a probate asset we're talking about, or where it's life insurance where the designated beneficiary is that spouse's trust. And then that could capture the $1 million exemption. And then you would, at the death of the surviving spouse, the survivor would have his or her own $1 million exemption. So that's the way you capture $2 million in Massachusetts.
Okay.
That used to be the law federally, but the federal rules basically allow, if one spouse doesn't use the exemption, you can port it over to the survivor. So, but that's only a federal benefit, we don't have that in Massachusetts.
Right. Well, and the next question I think is geared to those who are not married, because I know so many of these examples have been about couples and how they plan. Someone else mentioned they're brand new to this and 40, and they're single, and they said, if I remain single for the rest of my life, how would estate planning work? And are there different considerations for them, or is it the same as if you were married?
Well, I think there could be some different considerations.
Sure.
When you have no descendants and you're single, and let's assume you've outlived your parents. I think most clients or most Holy Cross alums, I'm going to say, would have a sense of wanting to know that their family was okay, and provided for. But there's been more time to develop different interests outside the immediate family, because single people don't have descendants, and they might have friends that they want to remember in different ways. They might be more involved philanthropically. They might want to provide more for charity. They might, be doing things. I think family will always be. My experience is that family usually remains important, unless there's estrangement and that can happen to anybody. But I think my only comment would be, typically you might see some other beneficiaries than just family.
Gotcha.
In the traditional married situation. Right.
Good. Well, and one of our listeners said thank you already. So thank you very much. And that wraps up the questions that have come in. And I can tell just from some of the additional comments that people are writing that we're really grateful for the time that you've taken to share your time and knowledge with us today. So thank you very, very much. As you'll all see, Joan's information is on the screen. And if you miss it, you do have a copy of the slides that you can download. I will follow up with an email, so you'll get a copy of this presentation, a recording, as well as a copy of the slides. You can always email me in the alumni office. I'm at msweeney@holycross.edu. I'm happy to provide the information. And I want to thank you very much for joining us. I want to thank Catherine and Bruce for bringing Joan to us. You'll receive a short email survey about this webinar, and I encourage you to share your feedback with us. That's how we can bring great speakers like Joan forward. If you have any follow-up questions, please feel free to reach out. And thank you again for joining us. If you're in the Northeast or wherever you are, enjoy the start of fall. We hope that you have a wonderful afternoon. Thank you.
Thank you.
Thank you, Maura. Thank you, everybody.